Good evening. Good evening, Immigration fam. I will wait for people to join so that we can get started on today's live. Today is January 22nd, 2026. And I have a topic that will require you to take your pen and paper. We need to talk about Board of Immigration case law that came down yesterday. Let's chat about it. Let's talk about what it means to you. And let's draw lessons from it. And basically, the essence of this is to help you become more knowledgeable, because knowledge is power, right? The more you know, the better you're able to make decisions about your immigration cases, the less likely that you are going to be a victim of unscrupulous people, right? So please join me this evening. Let's do this live. And hello to everyone. For those who are joining my live for the first time, and for those who have joined my live in the past, let me introduce myself again. My name is Ifeoma Odunlami. I'm an immigration attorney from the Odunlami law firm. We have offices in New Jersey and Texas, but we serve clients in all 50 states and even abroad. If you have an American immigration matter, we work on cases such as family-based immigration, humanitarian immigration such as VAWA cases, U visa, T visa, SJIS, asylum. We do removal proceedings. We also do R1 religious visas. So if we do waivers, we do consular processing. If you have any immigration matters and you would like for us to assist you, we would love to help you. So if you need to reach us, my number is 973-993-1900. I think it's on the ticker on, I think it's YouTube. Again, 973-993-1900. And the other number is 713-600-1909. So welcome, everyone. So, for those of you who are just joining, you know I'm an immigrant, and so the mission of my firm, our passion, is to help our fellow immigrants to live here in the United States lawfully, legally, without fear of being removed, without fear of being deported, without fear of losing their family. So those are the things that we can do because we're lawyers. We know the law. We work with the law to help you achieve this, okay? So hello, Lala Chan, how are you? Nice to meet you. So when I'm done, you can put your questions on the chat and I will answer as much as I can. But let's get started because it's already pretty late. So a case came down yesterday called the matter of SMH. It was a case that was decided by the Board of Immigration Appeals. And I want to discuss this case with you because it has some really valuable lessons. So basically, this case confirms what I've been telling you guys for years on social media, that what you file in your immigration processes doesn't disappear. It can affect you in the future, 20 years later, even if you withdraw it, even if someone else prepared it for you. That's the reason why you cannot treat immigration as a guessing game. This is serious matter, and it's always been serious matter, regardless of who is in office, regardless, all right? So I want to talk about the case of this woman, and I want to draw some parallels that would be, helpful to you guys. So this woman, in the matter of SMH, I have the case here. It just came down yesterday. I reviewed it. And so I will tell you what this case says. So this woman came into the United States and she filed asylum in 1998, okay? She filed asylum claiming that she was a refugee. She came from a refugee camp I think from Somalia or Kenya, I don't remember now. But in reality, she had Canadian citizenship, right? But she didn't disclose that. So when you file your petitions, they always ask you whether you have, especially for asylum, whether you have other citizenship, because for you to get American citizenship, American status, legal status, and under asylum, you're showing that you're afraid of going back to your country because you're afraid of because there's been past persecution, or you have a fear of future persecution based on five grounds. So this woman did not disclose that she was from Canada, and that would have made a big difference, because in Canada she would have to have proof that she was also being persecuted there. So she didn't say that, she kept that hidden. And even her asylum case was very colorable, right? The judge did not believe her case. He felt that there was a lot of inconsistencies. He said her testimony was implausible, and so her asylum petition was denied. Actually, first of all, it was denied by USCIS, and then she was placed in removal, where the judge also denied it based on the fact that they didn't believe that it was, it was real. So she filed an appeal, and then while the appeal was pending, it appears that she got married to a US citizen, right? And you all know this, that you can have multiple cases going on at the same time. I guess you guys must know this, because we've talked about this many times, right? So she filed a marriage-based case and made a motion to remand her, the removal based on a subsequent marriage to a US citizen. So the judge approved that. She adjusted her status. She became a green card holder. This was right around 1999. So for some reason in 2019, Department of Homeland Security filed a motion. Sorry, the Department of Homeland Services filed a motion to rescind her green card status based on the fact that they said that she failed to disclose that she was a Canadian citizenship. She had a Canadian citizenship when she filed for her asylum. And so basically that was fraud. So that was in 2019, and in 2022, a judge agreed that she filed a frivolous asylum petition, and therefore she was ineligible for any immigration benefits. So I'm going to break this down to you. Ineligible for any immigration benefits means that because of this fraud, this immigration fraud, this frivolous asylum filing, she can no longer get any green card benefits, even though she'd been a green card holder, right? Basically, that was it for her. And apparently she had withdrawn the asylum filing when she filed for her at some point, but it didn't matter. So this is the thing. From 1999 to 2022, this case is still haunting her. And so in 2026, yesterday, because she appealed the immigration judge's denial, the Board of Immigration Appeals made a finding. Now, her argument when she appealed the case was that she wasn't given notice of the consequences of knowingly filing a frivolous asylum claim. So she's not even saying that she's admitting that she lied on her asylum petition, but she's saying that nobody told her the consequences. And she also indicated that she had withdrawn her asylum application. So the BIA said the written warning in the asylum application itself is enough. You don't need the judge to reiterate it to you. You don't need anybody to go over it again with you. When you file the application, when you file that form, Form I-589, and you sign it, somewhere there, it tells you that there are consequences if your asylum petition is frivolous. And the judge, the BIA said that's enough, right? And the BIA also said it didn't matter that this happened a long time ago. It didn't matter that she had withdrawn her asylum. It didn't matter that she already became a green card holder. She was permanently banned from getting all immigration benefits, and now she had to leave the United States, all right? So I want to talk about this because a lot of immigrants, when you come into the country, you're coming to a new country, you don't know much about the United States. There are always people who are there to tell you, oh, this is how you're going to do it because, you know, I have this cousin who used this person. And a lot of times they take you to unscrupulous people who file petitions for you. They don't give you a copy of the petition. You don't even know what they filed for you, but they tell you sign here, sign here, sign there. And of course, being a newcomer, you're not asking questions. You're just assuming that whoever it is that, you know, whoever it is that's working with you, or whoever it is that referred you to this person, has your best interest. And I want you to know that that's not necessarily the case. I cannot count how many people come to my office and have been taking advantage of people when they first came into the United States. They'll take your money and they'll prepare some, some petition, and that's it. And this judge is saying that it's not an excuse that you didn't know. It's not an excuse that somebody filed it for you. You really have to review this document. You have to review it. And I know it's hard to review legal documents, but that's why it's important to work with people who are attorneys that are experienced and attorneys who are ethical, right? So the BIA pretty much said, you signed it, you're responsible for it. You cannot avoid a fraud finding by withdrawing the application, and there's really no statute of limitations on asylum fraud. So a lot of people come into the United States, like I said, people file these documents for them. Sometimes they don't even speak English, but so they can't really read the documents. But if you're in such a position, you really want to talk to somebody who knows what you need to know what you're signing. Don't ever sign documents, legal documents especially, without understanding what you have, what you're signing. So I wanted to tell you a story about a woman that we filed an asylum petition. We did an asylum case for her. She got her green card. So when she came to us, she had an interview. And so we requested all her records and we reviewed it with her. And as we're reviewing it with her, she said, well, I didn't say that. That's not exactly what happened. There were some inconsistencies in the petition that she filed that were inconsistent with what she told the person to file. Like the story she gave the person pretty much just changed dates, and just, I guess, to make the case more, stronger, they changed her narrative, right? So when we went over the documents that she sent to us, because we were going to go with her for the interview, and we're prepping her, and she told us that this wasn't actually accurate. We told her, we're going to have to correct it in front of the officer, because we cannot go with you and encourage you to tell a lie. We have to, as soon as we start this interview, we're going to tell the officer, this is inaccurate, we would like to correct it. And initially, she didn't want to do it. And we said to her, well, we're not the law firm for you. So she went back, she thought about it, and she decided to trust us. And we didn't give her any guarantees, because we're not telling you that if you do this, this is going to happen, but that's the right thing to do. And we had faith in her case, right? And we told her, you have a case that can withstand. So this person lying, telling all these lies on your case actually did you a disservice, and you need to clean it up, because even if you get through and get a green card, there's no statute of limitations on fraud. They can come back later. So let's do it right now so that you can get your green card and rest easy. So we went for the interview. As soon as we got to the interview, we said to the officer, we want to make some corrections. There was some errors in the previous filing. Our client is telling us that this is not what she told the person that filed for her, and this is her corrected statement. And then we did the asylum interview, and that was it. We came back. And I think it took maybe some months, and then they came back with an answer. They approved it. 1 year later, she filed, she got her green card. So what I'm saying is there are certain things that you need to know about filing immigration papers, okay? Don't file asylum if you don't qualify. A lot of people file asylum because they want to get a work permit. Well, that's not going to work this time, because these days, the Trump administration is handling asylum interviews on a last come, first get interviewed. So you file your asylum, they'll interview you within 3 months. You don't even get a work permit, right? And as soon as they interview you and you don't qualify, you're in removal proceedings. So you want to make sure that you qualify. And filing a frivolous case is not the same as filing a case that you don't win. There's a difference between a frivolous case, which is it's just everything in there is just lies, right? Like this woman's case, right? So she was actually a Canadian, but she claimed that she was a refugee from another country. She totally omitted the fact that she was in Canada and she had a Canadian citizenship. I think she was Canadian citizen. She totally omitted that. So her asylum case was a lie. So if you feel that you've been persecuted or you have a fear of future persecution in your country, don't be afraid to talk to an attorney about it. And you can file if the attorney, if it's an attorney you trust says, you know, you have a decent case, we can work. That's not a frivolous filing, right? You have to meet your burden of proof. But like I said, a frivolous filing is basically a filing that you lied straight up. So we'll talk about, don't let anybody create a story for you. Don't sign anything you didn't read and understand. Don't assume you can fix it later. And remember that withdrawing the case does not necessarily fix the issue. Now, let's talk about the do's, right? Always get a copy of everything you file. Review every line before signing. Work with a reputable, experienced attorney. Fix issues before USCIS finds out. We tell our clients, tell us the truth. Because if you tell us the truth, the ugly truth, there might be a pathway that helps you. I cannot tell you how many waivers we filed. We've been successful. Our clients have done things that would have disqualified them from getting a green card. Well, we filed a waiver, which is a forgiveness. And the forgiveness was accepted, was given, and now our client is able to go forward and get their green card, right? We had a case recently where a client had come into the United States with somebody's passport, with a false identity, right? And when she came, because some attorney had told her to say she came through the border. I'm like, no, but you didn't come through the border. You came with somebody's passport. So let's tell the truth. We'll file a waiver. And so we did that. The waiver was approved because there are waivers for immigration violations, right? And that's why it's important to talk to lawyers, because we know the stuff. We know that the USCIS does not expect you to be perfect. People make mistakes, and some mistakes can be forgiven. Not all mistakes. Some mistakes can be forgiven. And I'll tell you the mistakes that cannot be forgiven. A sham marriage is a mistake that's not going to be forgiven, except for very narrow exceptions. A false claim to citizenship cannot be forgiven. Same thing. And frivolous asylum, those three. Except the very narrow exceptions, typically, you're done. So it's important for you to tell your attorney so that the attorney can figure out if there's a legal pathway that can allow you to still get your papers. All right. So, some people are asking questions, so I should take some questions, and then I will sign off. So, somebody says they want a job in Ireland. I don't know how. You have to talk to an attorney in Ireland and see if there's a way for you to get there. Baba Femi, you're welcome. Samuel, I'm not sure what you wrote, but Alaji, your VAWA is 38 months now, still no updates. It's not abnormal. VAWA cases are taking 3.5 to 4, maybe even more. And, it's not abnormal, okay? So hang in there and just keep waiting, okay? Sooner or later, your case will come up and they will make a decision on your case. Okay, Political Pen, hello. Tordi Okorie says, I filed my VAWA since March 2022. This is 2026. Yep. I know it sounds like it's going to 4 years. VAWA cases are taking a little longer. It used to take 2 years, then it became 3 years, then it became 3.5. Now, like I tell everyone, just go to the case, the processing website. If your case is is past the case processing times, you have options. One of them, Analaji, one of them is reach out to your congressperson. reach out to USCIS. If we represent you, we can reach out to them. But ultimately, the best way to get your case moving is to file a lawsuit with, against USCIS, a federal lawsuit. A writ of mandamus is what it's called, okay? If you're serious about moving your case along, that's what you should do. So the immigration pause affects certain people that's in the US. Yes, certain people, not everybody that is a part of the pause. The 39 countries that were announced in December, it was supposed to be an entry ban, a travel ban, but it's also USCIS also decided to, pause. They create, their policy was that would affect the people in those 39 countries that had cases in the United States. So there was a pause. Now, remember, a pause does not mean that your case is not going to be decided. It's a pause because the government says that they want to go back and review their strategies, their policies, and figure out the ways that they want to, what is going to be applicable to those cases. And of course, there's lawsuits already. There are lawsuits filed, challenging this because it's really is not fair. And so there's a pause on adjudication of cases, but there's not a pause on submitting the cases. You can continue to put in your application. They are still working on those cases that were that have been filed. Even if you're from one of those countries, they're still working on it, but they're not going to make the final decision. That's what it is. The final decision is on pause. So if you have a pathway, file it now. And the reason is because if you don't file, you don't get to be part of those that, that can file a class action demanding that it's unfair, that your case should be adjudicated. That's number one. And number two, you don't know what the law is going to be. It might actually get worse. So I talked about this a couple of days ago. I had a client who, well, not a client, a potential client that did a consultation with me when President Trump came into office. That was January, right around January. She had a pathway. She had a child that could file for her. Her child was 21. And I remember telling her to file because, listen, you have a pathway and it's a really easy pathway, but she was afraid. She was afraid that filing would bring her to the attention of USCIS. And I told her, no, that's not the way it works. That's a pathway that will protect you, right? So she didn't file, and guess what? She's from one of those 39 countries that the adjustment of status has been paused. So, I mean, not adjustment of status, the adjudication for cases within the United States have been paused. Now, if she filed last year, literally within 4 months, she would have become a green card holder because for mothers, they tend to move those cases faster, and they were moving them really fast last year. And so now she is in a situation where if she has filed, or if she files right now, she doesn't know when she's going to get her green card. So not being afraid to file is really taking a risk on what future immigration laws is going to be. What if they decide that that's not a pathway anymore? You have a pathway right now and you're not filing. That makes no sense to me. I mean, I understand that you're worried, but fear you cannot let your fear, block your progress, So HG Ball says, my 10-year green card was approved after my marriage was 2 years and 2 weeks. Congratulations. You received notice to file I-751 removal of condition. Do I have to do that when I'm not a conditional green card holder? You shouldn't do that. So as long as you're sure that it's a 10-year green card, you're not supposed to remove conditions. You want to look at your green card, right? And make sure that it's 10 years, all right? Of course, I remember you, Alaji. So Miriam says, why is medical deferred action approval taking so long? It's almost a year. Yes, it's taking a long time. It's taking a really, really long time. And unlike other case types that tell you, like if you go to the case processing website, it will tell you how long. There's no such processing times for medical deferred action. And in the past, it would take really almost sometimes a year, sometimes 2 years. Now, honestly, we've heard people that say they filed their medical deferred action for like more than a couple of years and they're still waiting. So with medical deferred action, all we do is we keep reaching out. And one of our clients actually got his approved, but honestly, all you can do is keep reaching out, right? All right, so let me check on TikTok. What questions do we have on TikTok? All right. I'm trying to see if we can get questions. So Lionel Judah says, fingerprints after working permit was approved. Is that normal? Well, it depends on when the working permit was approved, because USCIS has a right to go back again and request that you do biometrics. But if the working permit was just approved and they're requesting that right away, I haven't seen that personally. It doesn't mean that they don't have, maybe there's something new there. You might want to talk to an attorney just to make sure that you're not one of those who have, I don't know, because these days they're trying to, yeah, but you can miss a biometric appointment. That's one thing you cannot do. But you might want to talk to an attorney so that we can get the total, we can understand your case and understand whether that makes sense. Because sometimes USCIS will request biometrics even after they've given you a work permit. Yes, they can do that. But I'm just asking, did this happen really like right after they approved the work permit? Are they allowing TPS holders applying for asylum? Of course, if you qualify for asylum, you can apply for asylum. All right. Let's see. So Dusan Sagan says, my I-751 interview is scheduled, but not the N400, not divorce waiver. Do I have a combo interview? Well, sometimes they'll schedule the I-751 interview on its own. Sometimes they do a combo. And sometimes they just schedule the I-751 interview and then you go there and they do a combo. But I've seen cases where they just do the I-751 first and invite you for the N400 later. So, I mean, be prepared. Okay. Even if you file an N400, they have a right to just schedule you for one and then do the other later on. So the Lord says, is there any possibility to go for interviews and come back if you have a good case with proof? So typically, the interview is the last stage, So, I mean, I don't know enough about your case to give you any other advice, but typically by the time you go for the interview, that's really it. But I would need to know what your case is about to determine if it's one of those cases that, you know what, let's just do it and see where it takes us, okay? Yeah, I would not recommend traveling. Nope, I would not recommend traveling. I'm going to tell you that. So Ajini says, I filed for my mother, but you still haven't heard back. Is this because of the new law? I don't know when you filed for your mother. Is your mother outside the United States? That takes a lot longer. Is she here in the United States and trying to adjust her status? When did you file? It really depends. And if your mother is from one of those 39 countries, you will get a receipt notice if you haven't gotten that, but you will likely not get an interview date yet, and likely not get a work permit either. All right, let me go to, let's see. Okay, I'm trying to get to, I know you guys have questions on Instagram. I just cannot access the questions. All right. I've seen a lot. Okay, here, that's one. So about that says, can I file an to expedite your visa? Your wife is pregnant since April last year. We're waiting for the interview. The NVC said all documents are good, and I even paid all the things. What can I do as a citizen? Honestly, that your wife is pregnant, I really, really doubt that they're going to expedite your interview because of that. But there's no harm in trying. No update on DACA. D. Jana says, I came 2 years ago. Can I say that I didn't know the 1-year requirement to file for asylum in my filing application? D. Jana is not going to make a difference because ignorance of the law is not an excuse. If you didn't file within the 1 year for the asylum requirement, you have to show extraordinary, some crazy things that happened that made you unable to file, such as you were in a coma, but not knowing is not going to cut it. All right. So Patrick says, I'm a Belgian citizen and I'm married to an American woman, but you're just married for 4 months. Can I file for a green card now? Of course, you can file the day after you got married, as long as you're able to meet the requirements of a bona fide marriage, bona fide relationship. It's always helpful to, like, if you guys have been living together for a while, you have joint financial documents, you have proof that it's a, that you're building your life together. You don't have to wait to file. There's no requirement that you wait a certain amount of time before you file for your petition. So if you're ready to file, go ahead and do that now. So Elvis says, can someone with a work permit and no criminal record be detained by ICE? Elvis, United States citizens are being detained by ICE. I mean, they're letting them go, but ICE seems to be detaining anybody that they can find if they think the person is not here legally. But the good news is either they let you go or there's an attorney there that's gonna get you out. Okay. So Abu says, can we talk in private? Of course we can. Give us a call, 973-993-1900 or 713-600-1909. Okay. So HG Ball, if you have a 10-year green card, you don't need to file. So are you saying that, because I'm not understanding your issue, if you were only supposed to get a 2-year green card because you received your green card before you were married for 2 years and they sent you a 10-year green card, then that's a mistake and you need to let them know it's a mistake. All right. But if you received your green card after you've been married for 2 years and the green card says 10 years, then likely it's correct. I'm not sure what you're concerned about, but if you have some concern that you're not able to articulate, reach out to an attorney and let them see, because it's hard for me to, I'm not giving legal advice over live. I don't know your case and I don't want to give you advice that you're going to rely on. So my lives are for informational purposes only. Reach out to an attorney, okay? HG Ball. Olumide Oni says, if I file for adjustment of status, can I go off F1 when my semester ends? Well, Olumide, what if your adjustment of status is denied? So if you're on F1, you got to be careful about a couple of things. You don't want to use the work permit that came with your adjustment of status because F1 requires you not to work outside the school. So if you do anything that violates your F1 because you filed for adjustment of status, and if that adjustment of status doesn't work, you can't get back on F1. So this is something that you might best be served by talking to an attorney so that they know exactly what's going on with your case and they can give you advice properly targeted to your situation. Okay. All right, guys. So Daisy says, if my fiance was born in a pause country, but is in a non-pause country, it's where you're born. Where is he from? That's what determines whether he's affected. Where is he from? Not where he lives. Okay. All right, guys. Have a good evening, and I will be back another time. Take care. Bye-bye.